More likely than not, that 0.01% is all it takes to tip the scales of justice. Join us as Inner Circle legend Charla Aldous, Eleanor Aldous, and Caleb Miller walk you through the critical moments, big decisions, and bold strategies that win high-stakes cases and show you how to turn that 0.01% into a game-changing verdict. You're listening to the podcast where winning is more likely than not. Produced and powered by LawPods.
Hello, welcome to the next podcast of More Likely Than Not, the Aldous Law Firm's podcast. We are so happy that you could join us today, and I'm going to remind all of our listeners that you can contact us at info@morelikelythannot.com if you have any questions about this podcast, our previous podcast, or any questions you want to ask on our future podcast.
All right, so today we decided we needed to do another in-house episode with the three of us.
And what's your name, sir, that's speaking?
This is Caleb. I'm joined with Charla and Eleanor. Of course, you already heard Charla. But basically what we wanted to do today is to expand upon a CLE that Charla did for me earlier this year. And when I said she did a CLE for me, let me give you some context. So I am one of the CLE chairs for Dallas Trial Lawyers Association. When I was looking to line up some really good speakers for the year, I didn't ask Charla, but told her she would be doing a CLE for our members in February.
This is true. He told me.
And then she said, okay, what am I supposed to speak on? And so we brainstormed some ideas, and we ultimately landed on an idea that was basically what Charla would tell young lawyers after her 200 jury trials and over 40 years of experience. But today, instead of narrowing it down to just young lawyers, we wanted to take the basic ideas that Charla explained to our members and to broaden them a bit so they would apply to everybody. And so that's why we're here.
And understand this, Caleb knew before he asked me to speak that I would rather try 100 jury trials than speak to a bunch of lawyers. It's not my thing. But he did. He came into my office and said, you are going to speak to the Dallas trial lawyers. And I have a confession, Caleb. I haven't told you this. I actually enjoyed it.
Well, good. It was the highest attended lunch CLE since I've been in Dallas Trial Lawyers Association. We had over 150 people RSVP, and they had to move in additional tables, which has never happened before. So, I mean, I'm glad you did it because our listeners
who
liked
would
it.
have thunk it? And I've got to add right now, we have a member of our team that just got in my lap, Loretta May, my most recent rescue dog, and she is our four-legged restraining order, and she's here to assist us in this podcast.
She also just yawned, so I'm not sure we're lively enough.
She does like to attend our podcast from time to time.
It's true.
All right, so let's get started. Eleanor, why don't you go ahead and talk to Charla about that first tip that she's going to give our listeners?
Yeah, of course. And like Caleb and Charla said, this episode is surrounding the 6 lessons every lawyer can adopt. So we're going to go through each of those lessons and kind of talk with Charla about them because let's be honest, everyone wants to hear from Charla. So lesson number 1.
Even my daughter?
Well, you know, maybe.
Depends on the day.
Well, it's funny because you were giving Caleb, you know, some what's a better way of saying crap? You were giving Caleb some crap for him asking you to speak in front of a bunch of lawyers, and all I could think about is you made me speak in front of a bunch of lawyers for the Avoda Dallas chapter. I had to give my opening statement to a bunch of lawyers.
This is really funny. My good friend Tom Melsheimer called me and said, I've got a great idea for Avoda. We're going to do an opening statement, and your daughter Eleanor is going to do one, and my young associate, I can't remember her name, is going to do one. I said, okay, that's great. And I went to Eleanor. I said, by the way, you're going to do a presentation to Avoda. She says, for what? I said, you're going to do an opening statement. She's like, Mom!
In front of all the best trial lawyers in the Dallas chapter. I'm like, sure. Let's do that. Anyway, I digress.
The best part of that, though, I was going to say is Charla had thought she had CC'd you or forwarded you the original email, and you didn't see it until like 3 days before.
Yeah.
Anyway, yeah.
Kind of a last minute kind of thing.
That's lesson 0, I guess, is don't trust Charla to not sign you up for something scary. But it was a great experience. All right, so lesson number 1, be authentic. So, Charla, I think anyone who knows you knows that you are an authentic duck, to put it lightly. You're always going to be yourself, and you always know that that's the best way to do it, not only in front of a jury, but for other lawyers, judges, court staff, regular people, clients, everyone, right? So let's talk a little bit about that. What can our listeners learn about the importance of being authentic?
You know, I heard a saying years ago that be yourself because everyone else is taken. I think part of the authenticity came from my background. I started practicing in Sherman, Texas in a small firm, and I really never had a mentor. So I just had to be myself because that's the only person I knew how to be. And what I tell young lawyers all the time is the most important thing you can do is be authentic. Don't try to be like this lawyer or that lawyer or somebody you admire. Just be yourself. Always understand that when juries come into the courtroom or when a voir dire panel comes into the courtroom, most of those people have never been in a courtroom before. So it's different from them. And they've heard the stories about uptight lawyers, ambulance chasers, all that kind of stuff. They need to see you as a human being just like them.
One of my favorite things that you do whenever the panel is called in is everyone has to fill out the typical background information, you know, who they work for, are they single, married, divorced, whatever, what their job is. And you always start out voir dire by saying, well, I had to learn all this stuff about y'all, and it doesn't seem fair to not share the same details about myself. So here we go. My name is Charla Aldous. I'm from Sherman, Texas. I'm divorced. You know, you show them who you are, and it makes them feel less, I guess, invaded upon, right? Because now you've shared with them the exact same details that they had to reveal about themselves and probably felt uncomfortable doing so. So
yeah, I even say I'm divorced and I'm not crying about it anymore.
Yeah.
And then I say I graduated from Grayson County Junior College. We called it Harvard on the Hill. What have you done? You've connected with those people who are intimidated by being in a courthouse with lawyers that they think are going to talk down to them. Mm-hmm. And that connection starts during voir dire.
And then not only with voir dire and with the jury panel are you being authentic, but can you talk a little bit about how you've interwoven that in your practice more generally, like with clients, with other lawyers, with court staff, with judges? Are there certain ways that you approach it other than simply just being yourself?
You know, it's not calculated, actually.
Well, of course, yeah.
I'm just kind of a hillbilly. I am who I am. But I always want the jury to remember that I'm just a person just like them. And let me just give you a couple of examples. I'll have a jury consultant there with me. Well, the voir dire panel is looking up there saying, who is this person? What is she doing? And I'm talking to her. And what is going on? I'm transparent with them. I'm like, this is a person that's here helping me, and when I talk to her, it means it's going to shorten the amount of time you have to sit on those benches.
Yeah, so then they're not mad at you every time you're talking to her.
And they understand, oh, okay, I get it. It's not hiding a secret. She's going to talk to that person about what next questions she needs to ask. And that's what I mean about being authentic. Just be upfront what you're doing. You know, don't put on a show. Just be who you are. You know, another thing I always like to do is bring into the trial the fact that I'm a mother of 4, Eleanor's my 3rd, and life experiences. I will never forget, I tried a case against the Episcopal School of Dallas, it was years ago, and my good friend Royce West was brought in to defend the school, which I was thrilled that a Democrat was going to make some money off the case. Sorry, I shouldn't say that, but it's the truth. And we had an all-female jury. This is a funny story. And at some point, Senator West stood up and said, Your Honor, I would ask you to instruct Miss Aldous to use her inside voice. I said, I'm so sorry, Judge. My outside voice comes more naturally to me because I've raised 4 kids. He said, well, Your Honor, I have 7. And I said, yeah, but I birthed my babies. And he said, well, I cut the cord. And this is an all-female jury. And I looked at the jury and I did the scissor sign. I said, snip, 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 pin a red rose on him. So what I'm saying is, just be yourself.
Yeah.
Let the jury know you're a human. You're not just a lawyer. You're a mother. You're, all of the things that you are.
I really appreciate how you're unafraid to do that, right? I think a lot of people, like you said, they have this vision of what a lawyer is supposed to look like or how they're supposed to sound, and they sometimes commit themselves to that rather than being themselves. And I remember when I was in college, I came and watched you try one of those cases. I think it was the ESD case. And you walked into the courtroom and you pulled up your pants and you go, ooh, I'm a big old fancy trial lawyer in front of all these super uptight lawyers. And it was just hilarious because it completely disarms people, but it's also just who you are. You're goofy, you're fun, you enjoy making people laugh. And I think that really comes through.
I forgot that. It was that the courtroom was packed every day. It looked like the Botox convention in Dallas because all the PTA moms were there. And they were all glaring at me, and I'm like, I don't want to go to your country clubs anyway. And I forgot I did hitch up my pants, say, ooh, I'm a big old fancy trial.
Yeah, she go, ooh, I'm a big old fancy trial lawyer. Yeah.
Everybody was embarrassed but me.
Oh, I wasn't embarrassed. I thought it was funny. But then again, I'm used to you.
Can I ask you a question, Charla?
Absolutely.
It's like going back to what you and Eleanor were talking about being authentic. I just remember as a young lawyer, somebody who doesn't have any lawyers in my family, somebody who didn't really have a lot of mentors early on, I was thrown in the fire. I had to go try a bunch of cases. And I looked to those folks on, podcasts or, doing, say, The Reptile, following Jerry Spence. What would you say to young lawyers in the position that I was in that are trying to adopt somebody else's style or think that, this is like Nick Rowley, he's real popular right now. He does trial by human. And I know a lot of young lawyers are trying to emulate him. So what would you say to those young lawyers who haven't tried a lot of cases, who are trying to copy some of the big shots?
What I would say is listen to what they have to say and use some of their tips, but don't let it affect your style, who you are and what you are in the courtroom. Because, you can't be me, you can't be Brian Panish, you can't be Mark Lanier. Just be yourself. Because I think sometimes lawyers get so caught up in, am I doing this right? Is this the right way? Is this a method? Is this what I should be saying? Just go in and try your dadgum case and understand you're talking to 12 people, just people off the street. So I think it's great to listen to podcasts, although I have to confess I never have listened to one yet, but I'm going to listen to ours. But don't let that get in the way of doing your own thing and being authentic.
I think that makes sense. So you're saying basically take in what others are telling you, but rearrange it to fit your style and who you are as a person.
That's exactly what I'm saying.
Yeah, that makes sense. I think that's pretty good for lesson 1, being authentic. Maybe we can move on to lesson numero 2.
Lesson 2 is be bold and confident. And so, Charla, can you tell the listeners what you mean by this one?
She has no shortage of that.
Yeah, I mean, we know because we see it every day. But for those who don't work with Charla,
let me tell you something. As a trial lawyer, you have to command the courtroom. And to command the courtroom, you've got to get outside yourself. And when I say that, you can't walk in and think, what are people thinking? How am I looking? What does my hair look like? What does my suit look like? What are my clothes? Forget all that nonsense. Go in and own it. Say, this is my place and I am going to own it. I think one way to do that is to always think outside the box. Don't just think about, well, I kind of have a problem with this, what the rules of evidence say you can do or what the rules of civil procedure say you can do.
Those are suggestions, right?
Yeah, just those are suggestions, exactly.
Those are guidelines, if you will.
One thing, when you said that, those are suggestions that came to mind, Caleb. I was trying a defamation case, and we got a $366 million verdict on a case where the judge had limited our damages to 28 days, and we had 10,000 economic damages. It was crazy. But in my client, I love him totally, but he's kind of a jerk. And he got up there and he was testifying and he was talking way, way too much. And while the defense were cross-examining him, I stood up and said, Your Honor, I object. And Judge Solis looked at me and he says, this is your client. And I'm like, I know. And I object because he's being non-responsive. He needs to answer the question. I've probably never told y'all that story. And the jury started laughing. And the judge says, well, she has a point. I'm going to sustain that objection. So the rest of the cross-examination, they would ask him a question, and the jury would look at me like, ooh, is he about to get in trouble or not? And I would start inching up from my chair, and he would hush. So it kind of deflected the arrogance that he had when he was testifying. And I say that with love because I really did love him. I didn't think through that. It wasn't a pre-planned thing. It was just I was sitting there thinking I'd rather be at the bottom of the ocean than listening to him testify. And I'm like, I got to do something to stop this.
Yeah.
So what do? You object.
But I think it's like what you've told us before. You want the jury to be looking to you for the answers. And how can you do that if you're not bold and confident? They expect, they see things on TV, they see all these lawyers, putting on a dog and pony show. And for those who haven't been in the courtroom, which is probably all of them, that's what they expect. And I think what you have told us here is you lean into that.
Absolutely, Caleb. You lean into it and just go with your gut. I mean, have fun. I actually think trials are fun. I know that's crazy. They're high stakes. And always think of what you can do to catch the other side off guard because they're usually uptight and worried what people are thinking. And don't give a hang about what people are thinking. I tried a case. It was the first methyl tertiary butyl ether case. I say that because I worked on how to pronounce it. That was ever tried in the United States against Conoco was, at least 25 years ago. And we tried the case in Wilmington, North Carolina, and Conoco had polluted our client's well water. It's water in North Carolina, by the way, not water.
Water.
Conoco had like 16 lawyers and 20 paralegals, and our team had 4 lawyers. And so it really was David versus Goliath. They had not offered any money on the case. And I had not told my team what I was going to do. But I thought, I've got to do something to let Conoco know there's a new sheriff in town, and you better get ready and buckle your seatbelt and put on your crash helmet because this is going to be the ride of your life. And what we did voir dire, and then the judge says, Miss Aldous, call your first witness. And I said, Your Honor, I call whomever on behalf of Conoco is going to tell the ladies and gentlemen of this jury if they take responsibility for polluting my client's well water. Well, you could see the seersucker suits converging on each other. They were powwowing. It was the funniest dang thing you've ever seen in your life. They're like, woo, 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 a total panic mode.
Yeah, not knowing what to do,
yeah,
how to respond.
And the jury's looking over there, and my team is sitting there, oh, my God, what is she going to do next?
I mean, it's a fair question.
And the lead lawyer for Conoco said, Your Honor, well, can we get a name? I said, yes, I'll take any of them. Anybody on that side of the courtroom, this case has been going for 2.5 years, who's going to get on that stand under oath and tell this jury if they take responsibility for polluting my client's well water. That's not a tough question. Either they do or they don't. Anybody on that side of the courtroom. And the judge says, well, counsel, she has a point, so why don't you just put somebody up on that stand? It was so funny. And they end up putting, I can remember this like yesterday, they end up putting a guy that was the vice president of the East Coast division of Conoco. I couldn't decide if he's a Gila monster or an iguana, but he had reptiles in his background.
So that's also a good example of being authentic because I don't think I could get away with that. And
yes, you know what, Caleb, don't say that. You can. What you got to do is loosen up a little bit.
Yeah.
Just kind of do your shoulders around and back and kind of think, okay, let's go in there and let's have some fun. Forget you're in a courtroom. Just go in there and think, what am I going to do that's going to make this fun? I always tell people, a jury, you've lost them if they don't look like they're at a tennis match, watching the ball here, back and forth. Keep it interesting. Keep it fun.
There's 2 points on this topic that I wanted to talk about, I think that are geared towards younger lawyers. Like I said earlier, I was kind of thrown into the fire early on. I didn't know what I was doing. I had to go try a bunch of cases in my first year.
And I want you to know this. I admire the heck out of that. You went and tried cases that, you couldn't win. Some of them you did, but you went and did it. And I don't care if it's a traffic ticket case. I don't care what it is. A trial is a trial is a trial.
And the experience, you're exactly right, was invaluable. But what I learned about the be bold, be confident, there were some of these cases I was trying where I was looking at the facts and I'm saying, how in the world am I going to win this case? It seems impossible. And I just remember having this epiphany, which if I don't believe it, the jury's not going to believe it.
Absolutely.
And so I think the jury can smell fear. And if you're not going in and being confident and believing what you're saying, they're not going to believe what you're saying. And part of that is not just being confident, it's having passion. You know, I don't have to tell you to have passion. You have probably too much passion at times.
I've been told that before.
But I have seen a lot of other lawyers, and I think this is probably more common with younger lawyers, although it could apply to anybody. It's like they go in and they're doing an opening statement or a closing argument, and it's going through the motions, and you're not in the moment. You're not, thinking I'm going to advocate for my client. And if you're not showing your confidence, you're not showing your passion, I think you're doing your client a massive disservice. So I think the first, for me, when I think about be confident, is you got to believe in your case, because if you don't, the jury won't. The second part of that, which I also experienced as a younger lawyer, is if you come across, it doesn't matter if you're in trial or if you're in depositions, as timid, the defense will take advantage of you. Depositions are a great example. How many times, you think young lawyers out there or more experienced lawyers earlier in your career, the defense would try to have speaking objections, or they're trying things to instruct their client. And if you're timid and you're letting them get away with it, they're going to do that the entire deposition. And so what I had to tell myself is early on, you just can't let that happen. And so even if you're not as sure of the rules of evidence or, that sort of thing, or those are mere suggestions at that point, you cannot let the other side know you're inexperienced or let them know you're scared.
I remember, this is reminding me, and the first deposition I ever took was in the midst of COVID. That's when I first became a lawyer.
You were in Philadelphia.
Yeah, I was in Philly, and I was taking a Zoom deposition, and it was my first one, and it was of an ENT. And I was, to put it mildly, very nervous, right? And I had my mentor lawyer who had very graciously allowed me to take that deposition. His name's Jim Waldenberger. He's the best. And he was on the Zoom with me. And when I tell you, this ENT was the world's biggest horse's ass that you've ever met.
Oh,
I know. Horse's tail.
I should have censored that.
I know. I'm sorry. But he really was. And he was so evasive. And then, like Caleb said, the defense lawyer was one who saw a young female attorney who could be bullied. And, I kept saying thank you. I kept saying sorry. And so I'm about 20 minutes into the deposition, and Jim texts me and he said, take a break. And so I go off, and he calls me and he goes, Eleanor, if you say sorry to that man one more time, we're going to have words. I want you to Hulk out. We're going. You've got this. You are right in this. And it just gave me the confidence I needed to know I was right. And so as much as it is an inner struggle that you've got to cope with, having support from mentors, from other lawyers, giving you the authority to know you're good, you're right, it really helps you in being confident as well. So don't be afraid if it's not all coming from you. If it's coming from others like Charla, Caleb, who constantly are helping me develop my confidence, that's okay too. It's good to rely on others for that.
I completely, totally agree. And even us old people like, affirmation and say,
Yeah.
okay, I believe in you. I think you're doing okay.
That's the funniest part, Mom. When I'm trying cases with you, you'll come up to me after and you're like, was that good? Every time without fail. And meanwhile, you've just destroyed, whoever was on the stand. But every time without fail, you go, was that good? And I'm like, yeah, it was good. But, it just tells you we're all human. We all need those reminders that we're going to be okay. You can be confident, you can stumble, but you'll have your team around you to support you and help you get back to that point of knowing you can be bold, be confident, and you're going to win.
And one thing that I think helps you be bold and confident is to think, this is just another case for you. Now, we all take, I know you guys do. At our firm, we take our clients seriously, and they are like family to us. But understand, you're the voice for those clients on probably the only time they will be in a courtroom. And if you focus on them as opposed to yourself, it gives you more confidence.
That is so true.
Because I might not fight for myself, but I always tell people, don't jack with my clients or my kids, or you've got some problems. So if we focus on the clients as opposed to how we're looking or what we're doing, or it's not about us, it's about the client in their case, I think that really helps you be more bold and more confident.
And that's a good preview for one of our later tips.
Exactly.
I think we covered that. You want to move us to the next?
Yeah, so that was lesson 2, be bold and confident. Lesson number 3 is keep it simple, or as Charla would say, keep it simple, stupid. So we kind of touched on this in our first episode and then again with our episode with Brian Panish, but it is so important to take a legal issue and make it simple for regular folk on the jury. It's so often that we get so stuck in the weeds and we don't see the bigger picture that we lose our way. And we all know the best thing we can do for the defense is to make it complicated.
Absolutely agree. And for all of our listeners out there, one of the best books you can buy is Mark Mandel's Advanced Case Framing. You can get it on the AAJ website. And when I read the book, and Mark's a dear friend of mine, he's brilliant. What it did, it solidified things that I have done in my practice, but I had not done it with intention. It was just a gut thing that I had done.
An instinctual thing.
Instinctual. But after reading that book, I'm like, okay, this is why I'm doing it. And it's helped me formulate themes in cases since I got involved in the book. And by way of example, he says, talk about your 3 or 4 I just can't get over it positive points in your case. And then take your 3 or 4 I just can't get over it bad points in your case. And limit your cross-examinations and your direct examinations to those points. Rather than, there's 20 issues here or there's 30 issues here, just keep it simple, stupid. And he even talks about echoing that through every witness. And it's very powerful because I think sometimes we get so involved in a case and in the weeds of the case and issues that really don't matter.
Yeah.
And you cannot get a jury to understand that in a week or 2.
And I think we kind of had this come up with a recent case that we were involved in. And, there had been over 30 expert witnesses and all kinds of side issues. And when we were getting ready for trial, I think we had to really, really narrow it down and make it more simple.
Yeah, that's exactly right. It was a case that Caleb, you were brought in, you and I were brought in to help try the case. And we really tried to simplify the case.
And what I'll say is, I think we have unique perspective because we're brought in at the tail end of a lot of cases to just come in and try the case. And so when we evaluate these massive files that another law firm's been working on for 2 to 3 years, the first thing I think we do is we go through it. And like you said, what is the I just can't get over fact? Or what does this boil down to? And what we found, I'm going to let Charla talk about it, but having that unique perspective allows you to simplify the case. When it's our own case, we originate, we sign it up, we meet with the people. We get so far into the case, and when these little issues come up in the case, they seem like they're huge. But from an outside perspective, it's easy to look at those things and say, well, that's not really that important. And so I'm going to let you talk about that case because that's a perfect example for this.
Well, you're talking about the case in Decatur?
Yeah, that's right.
Yeah, it was a case where this truck driver was driving a trailer, pulling a rig behind his 18-wheeler, and pulled it into an area and left his trailer literally across the highway. Isn't that right, Caleb?
Yeah, it was in the middle of the night, too.
In the middle of the night, like 11:30 or something at night.
Had no reflectors on it, nothing.
No reflectors. And our clients come over the hill, and they hit the trailer. And one client was a paraplegic as a result of it. It was just a horrific injury. And everybody got caught up in the fact of, okay, was she drinking before the accident? And what do the reflectors look like?
And she wasn't driving, just to be clear.
No, she was not. Should they have had different color reflectors on the trailer so she should have seen, or the driver should have seen the trailer? And our
seatbelt issues.
Oh, yeah, that's right, Caleb. I forgot that. Issue is, was she wearing her seatbelt or was she not wearing her seatbelt? Was it just the lap band part of the seatbelt she had on or not?
The mechanism of
injury. And I'm like, that's a bunch of hogwash. What we need to concentrate on is the trailer was in the middle of the freaking highway. Mm-hmm. That's it. Period. End of story. let the defense argue over, was she drinking before? Were they all drinking before? Did she have her seatbelt on right? Did she not? Did they have the reflectors on? Blah, 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 blah. It doesn't matter.
And I think Eleanor brought up a good point earlier. When you do all this stuff, you play into the hands of the defense, because the more you get away from the simple fact that a trailer's in the middle of the highway, the more it seems like you're giving their arguments credibility. If you're spending time talking about alcohol and hiring a toxicologist to talk about it, and calling a couple witnesses on this issue, the seatbelt issue, the mechanism of injury, all this, you lose the strength of the argument, which is, in no situation should a trailer ever be in the middle of a highway.
Period.
Yeah.
Stop. That's it. And so when we were getting ready to try the case, I'm like, that's how we need to frame the case. You don't park a trailer in the middle of a highway. Period. Let the defense bring up everything they want, and we need to laugh it off, not give credibility to it by calling experts or whatever to refute it. Just say, this is ridiculous. It's common sense. We've had several rideshare cases that resulted in catastrophic injuries. One guy was a quadriplegic, and we've had rape cases. And you have to really simplify the issues in those cases as well. And the issue is the rideshare companies advertise that they're safe for people to ride in. If they've been drinking, it's a safe way to get home. Concentrate on that theme and what they do not do to ensure that these drivers are safe.
Yeah, and we've seen that whenever those attorneys representing the rideshare companies focus on the legal arguments of independent contractor or this or that, it totally loses the jury, because at the end of the day, it's common sense. If you know that this driver, based on prior experiences, has been unsafe, and yet you've promised this person a safe ride home, you're responsible. You just are. And it's as simple as that. Who cares whether it's independent contractor or whatever? That might be a legal argument, but it's not one that's going to fly with common sense jurors.
I've always said I feel like the law is an impediment to the jury.
It is.
I let Caleb,
especially in Texas.
I let Caleb and Eleanor deal with the law, and I'm just like, okay, just give me a jury.
There's one other thing I wanted to add on this, just a tip for all the firms out there. The way we do things, we really practice the keep it simple in everything we do. One other point that I think is huge for jury trials, pretrial. A lot of people treat pretrial as if I got to just throw all the conceivable exhibits I might ever want to use on an exhibit list. We're going to over-designate depositions. We're going to have 100 motions in limine, and we'll sue 12 different defendants and see what happens. And our approach is very different from that. When we parachute into cases before trial, the first things we do is we look at what is this case really about and how do we simplify it. Sometimes that means non-suiting defendants. Sometimes that means settling the smaller defendants out, because our goal is when you go to trial, you're going to have one target defendant. You're going to have a clear message that is going to resonate with the jury. And if you have 7 defendants and you're trying to put 10 to 20% on each one, the jury's going to look at that as that's not a clear argument. The other part of this is our exhibit lists are extremely short. We will keep 20, 25 of our strongest exhibits that we know 100% we're going to use. And if there are things that come up during trial, we can actually offer those in the trial. And not only do we do that, we're very short with and very specific with our motions in limine and trial briefs. And our deposition cuts, it's only what we have to play. If we know we're calling those witnesses live, we don't do them. And I think when we go into trial, we simplify it for the jury, but not just that. We're showing the defense that we're ready to go.
Yeah.
You know what our case is going to be.
No, that's so true. It reminds me of whenever we're on a case and we're going to trial and we're looking at the defense's motions in limine, and so many of them are silly, right? You could fight them, right? And you could probably win, but my favorite is going into Charla's office and her saying, I don't care one hill of beans about that.
You know what I mean? That's most things.
Yeah, exactly. So as long as you just don't fight just to fight, you can still win a lot by keeping it simple and just saying, you know what, I don't care about that.
The thing is, pick your battles.
Yeah.
Pick your battles over the things that really, really matter. The rest is just background noise.
That'll be a sub lesson within Keep It Simple.
Okay.
All right. That's lesson 3, keep it simple. Lesson number 4, Caleb's going to talk about, and that is pick up the phone.
Picking up the phone, this is simple at our office, and Charla says this more often than not. There are some occasions where, you're fighting with the other side, there's emails back and forth, and you go and we'll talk to Charla about it. What would you do? And Charla always says, pick up the phone. And that has been a motto around our office. And I now almost 8 years here, I see why we do what we do. There's a lot of keyboard warriors out there.
Oh, I love that. I love that. Keyboard warriors. That's real. Did you come up with that on your own?
I wish I did, but no. It's just, they're like paper tigers, same thing,
like
right?
it.
But it's easy to get started out on the wrong foot. And my experience has been fighting just to fight. I mean, rarely does that lead to a better result for your client. And so Charla has these great relationships with almost every defense lawyer we've ever had on our cases. And so the way we practice around here is we'll fight when we need to fight, which is in the courtroom or, at hearings in front of the judge. But there's a lot of things we just don't need to fight over. And when we start our cases, sometimes the very first thing we do is pick up the phone and call opposing counsel.
And I got to tell you, I've been doing this for 40 years, so I'm kind of old school. And understand this, Eleanor and Caleb, when I started practicing law, we didn't have the internet. We didn't have emails. I mean, we had carbon copies of documents that you sent in snail mail. So mine comes from back when we didn't have all this stuff. And all you did was you talked to people. And I really do think that our profession has gotten to the point where it's all by email or text message or something like that. And you lose the humanity in that. Because you can think somebody's saying one thing and they don't mean it the way it comes across in an email. And I am a firm believer in just pick up the frickin' phone and call and talk to someone about that. There might be some defense lawyers who disagree with me. I usually get along with most all of the defense lawyers. If they lie to me, then that's a different idea. But understand everybody's doing their job and try to be cordial, try to work through things. Don't fight over the things that don't matter.
You've always really helped me with that because when I started out, I would take things personally, right? I would assume, oh my gosh, these are terrible defense lawyers doing horrible things, but you've really helped me with that, Mom, in understanding, look, they're doing their job. They're representing their client. Also, you don't know how much of it is from the client as opposed to the lawyer. We're all human. There's no need to have a back and forth that's nasty with a lawyer. Just tell them, look, we disagree. We'll figure it out however we need to figure it out. And it's really made life a lot less stressful because you're not taking things personally.
I love to hear that because, sometimes the lawyers are writing the letters because the general counsel is going to see it or the insurance adjuster is going to see it. And when you pick up the phone and talk to them, you can get down to, what do you really want and what is your goal here? And I think that's very important, and to not take it personal. We're all just doing our jobs.
Mm-hmm.
There's a couple other things that I think we've learned here, right? I like what we say often, which is when you send an email, assume that that's going to be an attachment on exhibit for a hearing.
Absolutely.
Because there have been times where we've been in that situation where there's some unfortunate emails that were sent. Usually it's from the other side, not from us. And you're at a motion to compel hearing, and the judge is looking at those like, well, it seems pretty easy that this is relevant. You should produce it. But your response is basically, F you. Yeah, I'm not going to say that. And so one of our rules here is assume whatever you type, whatever you say will be an attachment to a motion at a hearing and will be read by a judge. The other thing that I heard someone say one time that I want to share, and Charla, you can talk more about this because you have way more experience on this than I do, is I had a defense lawyer one time, a really prominent defense lawyer, tell me that in his opinion, there was a certain lawyer that got paid more on cases than most other lawyers in this particular field. That person had paid that lawyer a lot of money over the years, and I asked him, okay, what do you think about this person? What makes them better? What makes them worth more? And what they said to me is, everybody wants to pay somebody they like. And he's a very likable guy. He's a smart guy, but everyone likes him. And I thought that was a really weird thing to hear because I'd never heard somebody say they paid someone because they liked them. Usually it's, they're really good in trial or, they take really good depositions. But the more I think about it, the more I think that's true. And I want you to talk about that, Charla, because you have 40 years of experience settling and getting some massive verdicts.
Yeah, what I think that I agree with that, whoever said that, Caleb. You've never told me that before, but they want to pay more money to somebody they like. And what I have learned over 40 years is if you squawk and scream about everything, they don't take you seriously. But when a big issue arises and I'm ticked off and I look them in the eye and say, this is BS, they believe me. Because I don't fight over the little stuff. If you fight over everything, then it's insignificant when you're fighting over the big things. So pick your battles. Pick your battles on the things that really, really matter. And when they do, when it is a big battle, both of you know, I will not back down. I will be very bold, and they know when I say it, I mean it. One thing on the emails I was going to tell you is I always tell people, don't let your fingers do the talking.
That's good.
Don't talk with your fingers. Pick up the phone and talk with your mouth.
Yeah.
There's a couple other things I wanted to bring up because I do think our firm, and maybe not our firm, I would say mostly you, are unique in the fact that we actually get a lot of our cases from defense lawyers, which, before I started at the firm, I'd never heard of that. And not just defense lawyers, we've had former judges send us cases, current judges, friends or family members hire us, staff. And I think that goes into picking up the phone as well. There are times where, if you treat a defense lawyer bad, they're going to remember that 10 years from now. And when they have a good case, you're not going to be on their list. There's also times where people are rude to staff in the courthouse. And the approach we take is far different than that. And so can you tell the listeners, why do those things matter?
Oh, let me tell you what, if you're rude to staff, then, shame on you. The people at the courthouse work so hard, and you've always got to remember, and I don't think you have to tell this to people, they should actually know it, is those people talk to their judges, and the judges find out who is disrespectful to them. That's not a reason to be great to the staff. You should do it because it's just the right thing to do. But if you need a motivation, that should be your motivator, is how you treat people. And I get tons of case referrals from defense lawyers. And what I would like to believe is they, number one, know that I really care about my clients and that I will fight tooth and toenail, but I will tell them also if I don't think there's a case. And that comes through, years of, I've been doing this for 40 freaking years. I can't hardly believe it. But your reputation, it's like Benjamin Franklin said, reputation is like fine china. Once it's cracked, you can never repair. And always, always remember your reputation is the most important thing in the practice of law. And if you're a jerk to people, or you're dishonest with people, or you fight over things that don't need fighting over, people don't forget that.
And it's not just that. There are times where you're going to need something from the other side.
Absolutely.
What if sometimes something's calendared wrong? You need an extension, you need some grace, you need an agreement that you can go take an expert depo late, or you can designate an expert outside of the scheduling order. Good luck with that if you've built enemies from the other side because you didn't do the things like we said, like picking up the phone, or you sent some bad emails. You just never know. And like Charla said, reputation's everything. Part of it is trial verdicts. It's seeing that we care for the clients. But I think the other part too is how are you treating defense lawyers? How are you treating the people that matter on the cases you work with?
Just because you're a lawyer, you don't have to lose your humanity.
I was about to say, let's all just be human. Dang, it shouldn't be that hard.
Agree.
All right, so I think we covered that. So remember.
So that was lesson 4. Pick up the phone.
Lesson 5.
Lesson 5 is try cases. There's a saying that Charla always says around the office. I'm sure she's not the only lawyer who says this, but you're only as good as your last verdict. What do you mean by that?
You're only as good as your last verdict.
Yeah.
I've tried a lot of cases, and most of my big verdicts are because they didn't offer me anything, and you can't fall out of the basement. Those are the easy cases to try when they just don't offer you squat and you go and do it. But I think it's self-evident that insurance carriers and defense lawyers need to know that if push comes to shove, you will go try a case. Period. End of story. There are tons of litigators out there, but there aren't a heck of a lot of trial lawyers who are fearless and will go do it. I say that, but you also need to evaluate a case and try to evaluate it fairly. And remember, it's not your ego. It's about the clients. I've always had this saying verdicts feed egos and settlements feed families. You can't ever let your ego and your desire to get a big verdict to come to surpass your loyalty to your client and doing what's right for them.
So you said insurance carriers, and I think we all probably know this. If you don't know it, you should, but they're going to evaluate you based on, is this person going to be the type of person that's going to take the last best offer prior to trial, or is this going to be a person that is not going to take, our last best offer unless it hits their bottom line? You said you got to try cases, but I think the other point to this is you got to consistently try cases. There are attorneys who tried cases 10 years ago and may have been a hot shot 10 years ago. But the point that you make to us is when you say you're only as good as your last verdict is there's got to be a recent one. So what you did 5 years ago doesn't matter today, right?
That's exactly true. And another big thing that I think is important is if you ever give them your bottom line, this is what it's going to take, only do that if you're going to stick to it.
I was about to say that is one of the top lessons I've learned from you is you are a woman of your word. If you say it's going to take X amount, it's going to take X amount. And if they don't put it on the table, we're going to trial.
If you say that and then you start whittling away, then you lose your credibility. I feel like with my trial experience and how long I've been doing this and focus groups and Verdict Hub and everything that we use, we know how to evaluate cases. And when you tell somebody, if it's through you don't obviously start with your bottom line, but through mediation processes and, negotiations, and when you finally get down to the nitty gritty and you say, it's going to take this amount of money to settle this case, period, end of story, don't back down from that. And I got to tell you, most every time that has happened with me, they end up paying it. It may be, well, we got a jury in the box, but they usually end up paying it.
But that only works if you're willing to try cases.
Absolutely.
And if they know you're willing to try cases. Because how many times have we also said, here's our bottom line, and they haven't paid it.
And we had to go to trial.
And we had to go to trial and take a verdict.
And you know what, Caleb, I knock on wood, I have yet tried a case where I got less in the verdict than was offered in settlement negotiations. That would be a hard pill to swallow if I had left money on the table. And people oftentimes ask, how do you evaluate it? A lot of it for me is just my gut. I just have a feeling on what's right and what's wrong.
Well, and I think you have a really good sense of people and what will ignite them to render a large verdict. From your ability to connect with others, what's going to really make them angry and what's going to deliver the value that you believe the case is worth.
So I'm going to go back to trying, how do we try cases? Or a lot of people will say, well, it's just too hard to get in the courtroom, or, everything settles. And I think part of that is you're probably, if everything you have is settling, you're probably not asking for enough money, right?
You got really good cases, better than we do.
Yeah, all your cases are on videotape and they're all laid down liability. But I think part of that is you need to, like Charla said, you need to stick to your guns and you need to be able to say, here's the value and I'm not going to move away from that value. But the second thing we hear a lot is, well, I just can't get trials. And, this was a problem that Eleanor and I have. We only have at our firm, we have, any given time, 15 to 20 cases. Our cases tend to be fairly sizable. And, this isn't going to be surprising to anybody, but when we're brought in as co-counsel, everybody wants Charla to be first chair. And so
that's going to change in the future.
And we're working on it.
I firmly believe it.
One of these days, we're working on it. But, it's not surprising because somebody is giving us, in a lot of cases, half the fee or whatever it is. And they are doing that because of Charla's reputation and her trial skills. So Eleanor and I have struggled with getting a lot of trial experience. We may do, a witness or two in one of our trials and kind of be third chair and help with pretrial. But for a lot of you young lawyers out there who actually do want to try cases, it's not as easy as what you think it would be. And so I'm just going to tell everyone what we started doing because I think this is actually working really well. Everybody will know either lawyers who prefer not to try cases and they like to run their firm and they like to, maybe take depositions, but they don't feel as comfortable with trials. Or those lawyers that have so many cases or multiple trial settings that they need help. And so what we started doing is we've offered to be first or second chair for free in any of those trials that folks have that maybe they need help or they don't want to try. And what we're finding is once we started doing that, we have about 3 to 4 a year that we're able to go try. Now, the part that's hard is we keep getting reset on these trials, but
which is such a bummer.
It is, but I would say for all of you out there who say, well, none of my cases are going to trial, if you really want to get trial experience, you can figure out how to get trial experience.
And I got to say this, I started out in Sherman, Texas, and I was a traffic queen of Grayson County. The firm that I was in, I didn't get enough business coming in, so I started doing traffic tickets. I tried so many cases in municipal court, traffic citation cases, and people might think, oh, that's so far beneath me. No, it's a trial. And a trial is a trial is a trial. You pick a jury, you put on the evidence. It's like riding a bike. The more you do it, the better you get at it. And I have encouraged Caleb and Eleanor to go out there and just find cases that they can go try, because that's how you're going to get the reputation with insurance carriers and defense lawyers to know that you yourself are not afraid to go to trial.
And I don't think it's just that. That's like a huge part of it too, to get value on your cases. But the other part of this is, unless you're getting reps in, how are you getting better? You can go to these CLEs, you can go to these conferences, you can listen to podcasts, but unless you're applying it in real life, in a trial, you're not going to be a better trial lawyer. And I did want to touch upon another thing that Eleanor and I started doing last year that I think was extremely helpful. I hope all you listeners have friends that practice law and that are trial lawyers that you can learn from, preferably those that are more experienced than you are. One thing we did a year or two ago is we formed what we nicknamed, Trial Lawyer Club?
Oh, yes. TLC.
And we got a few of our friends that wanted the same experience as we did, which is, we want to try cases, lawyers that we trust that have talent. And we decided, hey, let's try to get together once every few months. And we first circulated mock trial programs, and everybody did, or problems, and everybody did an opening statement. Then what we decided to do is everybody actually take a case that you have. You're going to come up with an opening statement, and you're going to do it in front of us. And we timed it, and everybody wrote critiques. And I think that is one easy way to simulate trial experience if you actually can't get a trial. And the other thing that Eleanor did recently, preparing for a trial with another lawyer in Dallas, they were actually doing voir dire and openings in front of a focus group. And I thought that was an excellent idea.
Yeah, and shout out to Jason Franklin for not only allowing me, a younger lawyer, the opportunity to go try a case with him, but B, showing me all the ways in which you can become more prepared for those trials as a young lawyer. And like Caleb said, doing focus groups where you practice voir dire, where you practice doing your opening is invaluable. Not only does it give me more confidence, but it also helps me adjust. And like you said, reps make you better. You get better every single time. So yeah, I'm really grateful to those attorneys who are willing to give you and I the opportunity to really hone our skills and do better. It's a credit to our profession that there are those attorneys out there.
I think the point being, though, is if you want trial experience, it's easy to say, none of my cases are going to trial, everything's settling, but be proactive. There are ways to find trials. There are ways to simulate trials. I mean, we have AI programs now that I'm hearing can simulate voir dire.
Oh yeah, this was fascinating. I went to the Mark Lanier Trial Academy this past summer, and I'd recommend it for anyone who's wanting to hone some of their trial skills. One thing that he demonstrated is using AI, for example, Claude AI or ChatGPT, what have you. You can simulate a voir dire through AI. Now, Lisa Blue would tell you, well, it's not the same thing. It's not, but it might not be the same thing, but it's something.
It's something I'm not going to do, but
yeah,
I love it for
it's
you
something,
youngsters.
right? I mean, but I will say this, it's hard, right? We all have lives. We have our own caseloads. It requires a lot of outside work, a lot of time, effort. It's kind of like when you go to the gym and you're like, ugh. But if you prioritize it, you can make it happen.
Exactly right. And I think, that takes us to our final topic. Now, again, that was try cases. That was lesson 5. Coming from the person who's tried over 200 jury trials, I think the proof is in the pudding there.
Because I'm old.
There's not a lot of people who have practices, even for 40 years, who've tried 50 cases.
Yeah.
But that takes us to the last one. And Charla was talking about this a little earlier. That lesson 6 is clients first. And Eleanor, can you bring the topic up and talk to Charla about it?
Yeah. clients first. Growing up with my mom, I was fortunate enough to see her compassionate heart and see how much she cares for her clients and really imbue that in me, and not just as a lawyer, but as a person and as a human being. And that is kind of carried throughout my entire career, and not just as a lawyer, but in my other professions before I decided to become a lawyer. And everyone who knows Charla, they walk into her office and there's this entire section that is dedicated to our clients. We ask after every single case for them to provide us with a memento. And to tell you how special those are for each of us is beyond words. I mean, we just recently received a beautiful book from one of our clients, and it's on flowers. And she told us that she believes every woman is like a flower, unique and beautiful in its own way. And she wanted to gift that to us. And I think she said Charla looks like a red Rohesian or something like that. Yeah, and I didn't know what that meant, but it sounded cool. And I don't know, now every time I walk by our area where we have client mementos and I see that book, it reminds me of why we do what we do. And that's a credit to you, Charla, because you've made sure that that is the central focus of our firm. So can you just tell us a little bit about that?
When I started being a plaintiff's lawyer, I really committed myself to trying to not make this about me or the money, to make it about the clients, and to check myself morally always to make sure that that was my first motivation, is to help people. And I did. 35 years ago, however long, I started asking clients to give me mementos when we ended a case, lose, win, or draw. And I got to tell you, this is a hard profession because we see so much tragedy and so much sadness. And if you really care, it wears you down. It really does. But when I get down and I think, oh, I don't know if I want to do this anymore, I go to that section of our office and I look around at the things that people have given me, and I think about the difference that I made in their lives. And I'm like, okay, I got another fight in me. There's so many times we've got a cowboy hat. Y'all probably seen it. It's a brown velvet cowboy hat.
Yep.
And that cowboy hat was Bob Garrison's. And about 25 years ago, I represented Bob in a failure to diagnose cancer case, and he was dying. And he told me, he said, Charla, all I want to make sure of is when I die that my wife and my 2 children are taken care of, because his wife was a homemaker. And I said, Bob, I'll do everything within my power to make sure that happens. He was going through chemo, so he would come to see me and he'd wear his cowboy hat because he was losing his hair. We ended up getting the case settled. Fortuitously, it was 2 weeks before he died. And he came to my office. I can close my eyes and remember it like yesterday. And he signed the settlement documents, and I gave him the check. And he took the hat off of his head and put it on me. And he said, you took care of my family, and for that, I'm eternally grateful. What a gift to be able to help people in their time of need. Steve Maloof and I tried a case 28 years ago. Rachel Martin, Rachael. Her parents were very particular about spelling her name right. And Rachel was born with cerebral palsy, and her parents had done everything in their life to main school her, and she had just done so well. And she had a condition called subglottic stenosis and was going in for a minor surgery, but she had to be consciously sedated for it. And the pediatricians, the pediatric intensivist, gave her propofol, which you all know is what killed Michael Jackson, Diprovan, it's called. They gave her 4 times the recommended dose, and her urine went from tea-colored to coffee-colored to brown to black, and she died of a condition called rhabdomyolysis, which, if it had been caught early, absolutely would not have been fatal. One thing that's really cool, we sued AstraZeneca in that case, and part of the settlement with them is they put rhabdomyolysis as an adverse reaction to the drug. So hopefully, if this happened to any other patients where they started developing rhabdo, people would look at it and say, oh, we need to be aware that this drug can cause this. Anyway, long story short, we got, I can't remember, $268 million verdict. The doctor settled. The hospital was obstinate and would not settle with us. After that settlement, Wayne and Brenda Martin brought me Rachel's original birth handprints in a frame and said, "You are the angel who protected our daughter and made her death not be in vain." And I got to tell you, when I look at that from 25 years ago, it gives me the impetus to say, okay, I can go and do this again.
And I guess the question now I have, for anyone who knows you, they know that the clients are always first. You can, like Eleanor said, you walk in our office, there's mementos everywhere. Our clients text us, they come and visit us randomly, they pop in all the time. As far as being a good lawyer and being a great lawyer, how does the perspective of keeping your clients first change what you do? I mean, what's the difference between those lawyers who always put the clients first versus those who do not?
I think a lot of it comes down to when you're talking about settlement value of cases, honestly. There's some cases that it's easy. This case is worth $100,000 or, $500,000. But I have had cases in my career that I really wanted to try them. And I knew I would get huge, huge verdict, like hundreds of millions or billions. But I had to look at it and think, but is that best for my client? Because for me, it's another trial. For them, it's their life. And it's tough to go through a trial, to put a client through a trial. And if the insurance carrier or the company offers life-changing money, you've got to really dig deep and think about that. I think sometimes we as lawyers hear about the $100 million, the $500 million verdicts, the $150 million settlements. But sometimes you got to look and say, how much money does this client need? Truly. We had a case that we recently settled for a lot of money. And if we had tried the case, it would have been an astronomical amount of money for a verdict. But that would have been 2 years down the road. In the meantime, our client, who is a paraplegic, wouldn't get the care she needed, wouldn't have the house renovated that she needed. And the amount of money that was offered, she would never spend that in her lifetime. And so I really think that that's when it gets down to putting the clients first. What is best for them? Not what's best for your career, not what's best for all the lights, cameras, and action, but what is best for the client.
Now, not to get into history too much, but I was reading something the other day, and I thought this is perfect to what you just said. So lawyers actually started, the profession of being a lawyer started because in the Greek time, there were those who could not speak for themselves. And there were orators that were allowed to step in and to speak on behalf of those who could not speak for themselves or were not comfortable speaking for themselves. So our very profession originated from those to be a voice for someone else, and they were not paid. It was a volunteer thing. And so sometimes I think about that.
I didn't know that, Caleb. That's beautiful.
I don't even know why I know it. I looked it up. There is a reason I looked it up a few months ago, and I can't remember why, but it hit me in that moment. I mean, isn't that what it's about?
Absolutely. I always say I'm a voice for those that, but for me, wouldn't have a voice. Eleanor's heard me say this so many times. I feel so blessed and so lucky that I've been able to make a good living, support my kids, educate my kids, and doing it while helping people who need me. And it feeds my soul.
And without clients, what do we have?
Nothing.
Yeah, we wouldn't have a job but for them.
Well, and it, naturally feeds into everything else we've been talking to. You can be bold and confident if you know you're putting your client first.
Absolutely. Forget about yourself.
Yeah, you can do so many things and feel so empowered if you're advocating on behalf of someone who needs you to be their voice for them.
And the other part of that too is, remember, you can be a voice or you can do great for your client no matter how big the case is. There's some cases that I'm sure could be $10,000, but to that person,
it's huge.
It's huge.
It's their life.
It's whatever it is. And so I feel like, we tend to talk about the $100 million verdicts or the big settlements, but it's about no matter what you do, no matter what the issue is, whatever case you're taking on, you're putting the client's interest first. And if you put the client's interest first, or you think about, if I hired a lawyer, how would I want them to represent me or my family? If you have that mindset, everything else in that case is going to go well. You're going to fight for them. You're going to take better depositions. You're going to do better discovery. You're going to try a better case.
Yeah, I think that's right.
And you know what? I got to say this. I love practicing law with you two.
I like practicing with you. This is fun.
Yeah.
I like how we came in about, 15 minutes before we're going to start?
Yeah.
Let's just go.
Let it roll.
What are we going to talk about today?
Yeah. So those are the 6 lessons. You know, take it or leave it, but it's what's worked for us. It's what's worked for Charla over her 40 years, me for my baby lawyer years, and then Caleb as well. And so it's
his
been
adolescent
fun.
lawyer years.
Yeah, his adolescent lawyer years, exactly.
Anyway, thanks everybody for listening to More Likely Than Not. I just love that name, and we've got it patented, don't we? Or copyrighted or something.
Something fancy.
Something like that.
Anyway, thank you for listening to More Likely Than Not. Again, if you have any questions about this series or any questions about future series that you would like for us to answer during our conversations with people, email us at info@morelikelythannot.com. And I've got to tell you something I'm really excited about. Our next episode is going to be featuring one of my all-time heroes, Jim Perdue Sr. Jim, when I was a baby lawyer, anytime he was speaking, I would move heaven and earth to go and listen to him because he's such a fascinating storyteller. And he has given me so many tips over the course of the last 20 years or so that have helped me as a trial lawyer. And we're thrilled to have him. And I guarantee you will learn some great trial tips from such a legend as Jim Perdue Sr.
Any suggestions, anything at all, please email us at info@morelikelythannot.com. Thank you.
Thanks, everybody, for listening. I think you can tell, and we at Aldous Law here, we actually kind of like each other, and we absolutely love what we do. And we work a lot of our cases up from the get-go, but we're brought in on cases a lot. We try cases all across the nation. If you have a case that you're interested in talking to us about, we'd love to hear from you. We've tried everything from trucking, workplace injuries, explosions and burn cases, dram shops, rideshare sexual assault, birth injury, your personal injury cases. If you need a partner to help you with your case, please call us. We can be contacted at aldouslaw.com. We'd love to hear from you.
You've been listening to More Likely Than Not, where the Aldous Law team turns small margins into massive victories. Love what you heard? Don't miss an episode. Subscribe now, leave a review, or share this with a fellow trial warrior. Remember, we're all just 0.01% away from tipping the scales. Produced and powered by LawPods.